Something big just happened, and it could change the way we fight for our right to keep and bear arms. Every day, it seems like there's a new threat to our fundamental freedoms, but this time, the Department of Justice is the one shaking things up. In this video, we'll talk about the DOJ's major announcement on Second Amendment litigation, why it could mean a massive shift in how firearm regulations are handled, and how each of us in the Pro-2A community can be ready for what comes next. For those who haven't heard the backstory yet, the DOJ has been involved in multiple lawsuits that directly affect our firearms rights, especially regarding accessories like suppressors and the status of young adult ownership. Over the last several days, something extraordinary happened. A DOJ staff attorney took a position that suppressors are not protected by the Second Amendment in the U.S. versus Peterson case, and that position infuriated many of us who believe the right to keep and bear arms should include the tools that make firearm usage safer and more effective. Almost immediately, there was pushback, and the DOJ found itself backtracking, or at least rethinking its approach. Some of us felt like the left hand didn't know what the right hand was doing, because different parts of the DOJ were making conflicting statements about what the Second Amendment means when it comes to accessories like suppressors. Despite that confusion, an official communication from Chad Mizelle, Chief of Staff to Attorney General Pam Bondi, confirmed that the DOJ is planning to reevaluate its positions on the Second Amendment, including those relating to suppressors. That is the big news, an announcement that might hint at a more robust recognition of how essential these items are to our rights. Before we dive deeper, I'd love to hear what you think about this DOJ turnaround. Do you believe they'll genuinely support our rights, or is it a temporary move to calm the uproar? Drop your thoughts in the comments below, because we need to stay vigilant and keep sharing our perspectives. Our voices do matter, and when we speak out as a community, we remind the government that we expect them to respect the rights guaranteed by the Constitution. Now, let's go step by step to break down how we got here. First, we have the backdrop of Brown versus ATF, a case dealing with whether certain federal restrictions on young adults owning firearms violate the Second Amendment. There was a separate argument in U.S. versus Peterson, in which the DOJ argued that suppressors are not even arms covered by the Second Amendment. Most of us in the Pro-2A community see that stance as absurd, partly because the National Firearms Act itself classifies suppressors as firearms. We also know they are accessories that help reduce the risk of hearing damage. Many folks in other countries actually think it's irresponsible to shoot without a suppressor because preserving hearing is common sense. Yet, in America, we're saddled with regulations that treat these items like contraband. Worse still, the Fifth Circuit Court of Appeals had previously upheld the argument that suppressors aren't protected by the Constitution. That's the kind of ruling that defies reality, especially in light of clear logic indicating that an accessory designed to protect hearing is no more dangerous than earmuffs or earplugs. When the DOJ doubled down on that perspective, a lot of us spoke up about the misinformation and the potential violation of our constitutional rights. It turns out that not everyone in the DOJ was on the same page, because within 2 days, there was a swift about-face, at least from the higher-ups. Chad Mizelle's message effectively announced that the Department of Justice, led by Attorney General Pam Bondi, would be reassessing some of the litigation positions that conflict with the principle of defending the Second Amendment. This came almost immediately after a DOJ staff attorney had filed a letter pushing the exact opposite narrative in a young adult firearms rights case. Talk about timing. It seems that the department realized they needed to get ahead of a public relations crisis, especially among those of us who care about preserving our constitutional freedoms. We all remember Pam Bondi from her time as Attorney General in Florida, and let's be honest, she wasn't exactly celebrated as a champion of gun rights back then. There were situations where she appeared open to state-level regulations that didn't sit well with many of us who fight daily to uphold the Constitution. However, she's now in a position where many of us will be watching carefully to see if this alleged shift is genuine. The question is, does she truly respect the constitutional principle that shall not be infringed, or is this a politically motivated move? We can remain cautiously hopeful, but history has taught us to verify claims before we trust them. The interesting part here is how quickly the DOJ can change its stance when enough attention is brought to a case. They don't require protracted internal reviews or multi-year policy processes to announce that they are no longer going to argue a particular view in court. If they truly believe that suppressors are integral to exercising the right to keep and bear arms, They can simply file a motion stating they no longer stand behind the old position. That's how the legal system works. A shift in strategy can happen in a matter of days if there's a political or legal advantage to it. So for the DOJ to say, we're going to reevaluate, is a signal that they might be ready to do exactly that. Let's see if this reevaluation leads to genuine changes in the government's approach to suppressors, or if it's merely a cosmetic gesture to calm the public. From our vantage point, suppressors are crucial accessories, not only because they make shooting safer for our hearing, but because they also reduce noise pollution and limit potential disturbance in areas where responsible gun owners train or hunt. The United States is bizarrely out of sync with many other countries that view suppressors as a standard health and courtesy tool. The fact that you have to jump through hoops, pay hefty fees, and fill out excessive paperwork just to protect your hearing is mind-boggling. That's why this DOJ announcement could be huge. If the DOJ reclassifies suppressors under a perspective that they are indeed covered by the Second Amendment, and that the National Firearms Act is out of step with constitutional principles, we might finally see a court battle that leads to more consistent treatment of these items. Many ongoing cases will be impacted if the DOJ decides to align itself with a more pro-Constitution framework. Beyond suppressors, there are lawsuits regarding magazine restrictions, age-based bans, and other arbitrary regulations that choke our Second Amendment freedoms. It's not unrealistic to think that if the DOJ changes course on one front, it may signal a broader policy shift. If the department under Bondi is now willing to say, we no longer believe certain aspects of these regulations are valid, it could send ripples throughout the legal system. Judges and state governments pay attention when the DOJ modifies its approach. It might encourage more states to reconsider their own strict regulations or face challenges in court with less federal support for those restrictions. While there's a reason for optimism, we can't let our guard down. One of the major pitfalls we face is complacency. If too many of us assume that the DOJ announcement will instantly remove every hurdle, we risk being caught off guard when the government or certain state-level officials attempt to push alternative regulations. Sometimes politicians who sense they're on shaky ground with a certain argument will turn around and target a different angle. They might say, all right, maybe we'll leave suppressors alone, but we'll go after braces or other accessories. That's why vigilance is crucial. We need to stay engaged, share updates, and keep the pressure on at every turn. A perfect example of the power of community pressure is what we've just seen. The DOJ made a quick pivot, and that wouldn't have happened if people hadn't raised concerns about its contradictory filings. When we call out anti-Second Amendment rhetoric, we hold government agencies accountable. They can't hide behind a lack of public outrage if we make sure everyone knows exactly what's going on. That's why it's so important to talk about these issues with friends, family, and fellow advocates. Never underestimate how impactful sharing a piece of news or clarifying a misconception can be. That's also why channels like this exist, to make sure the word gets out and no one can pretend they didn't know what was at stake. For those of us who train regularly or carry daily, the capacity to lawfully own and use accessories that enhance safety is non-negotiable. Suppressors are about more than just reduced noise. They can make a defensive or training situation safer for everyone involved. The fact that we've been forced to treat them like contraband for so long is a reminder of how pervasive government overreach can be. The National Firearms Act is decades old, written in a time when lawmakers were influenced by sensational stories and had no problem burdening lawful Americans. Today, we have clear evidence that suppressors offer genuine benefits, yet we're still navigating antiquated laws. That's why watching the DOJ reevaluate its stance is so significant. If they're even willing to consider that their previous approach was misguided, we might see other challenges to the National Firearms Act gain momentum. On that note, I'd like to express my gratitude to Arrowhead Tactical for sponsoring this discussion. For those of you new to the brand, they create athletic apparel specifically designed for concealed carry, which is a huge deal for those of us who want comfort, flexibility, and discreet firearms carry. Their joggers, shorts, and holsters allow you to be ready while working out, running errands, or just doing everyday tasks. Personally, I appreciate how their gear stays in place and is designed for shooters by shooters. If you're in the market for clothing that supports your everyday carry lifestyle, check them out. It's partnerships like this that help keep these conversations going, so we can stay on top of the government's moves and keep each other informed. At this point, I'm cautiously optimistic. The DOJ's announcement that they're reevaluating their position is definitely better than them doubling down. But as I said before, words alone aren't enough. The true test will come when we see whether the DOJ changes its legal arguments in active cases or files new court documents acknowledging that these regulations are in conflict with the Constitution. If they genuinely support the principle that our right to keep and bear arms must not be infringed, we should see tangible actions in the courtroom. That means no longer claiming that suppressors aren't protected. That means refusing to treat young adults like second-class citizens when it comes to firearms ownership. And that means demonstrating a willingness to challenge or at least not defend outdated restrictions that hamper our liberty. Our community will keep close tabs on this. The reevaluation could shift public opinion if it's handled in a principled manner. People who have been on the fence might finally realize that much of the narrative around suppressors has been rooted in Hollywood myth. The more we educate folks about real-world firearm usage, the safer we'll all be because we won't be beholden to inaccurate assumptions. Remember, a well-informed public is the greatest check on government overreach. When those in power know we understand the facts, they're less likely to try and pull the wool over our eyes. We also have to remember that we have multiple court battles in progress. Each time a federal agency revisits its stance, it can influence how local and state governments legislate. With Brown versus ATF, the question centers on age restrictions. With U.S. versus Peterson, it's about suppressors. And there are plenty of other lawsuits challenging limits on magazines, waiting periods, and more. If the DOJ takes a new approach in one or two high-profile cases, we might see a chain reaction. What do you think? Comment below, and please like, share, subscribe, and click on the bell icon for more of these videos. Thanks for watching.